from the College by the Lake, Coeur d'Alene, Idaho. Local, regional, national, and international guests discussing the issues and topics affecting the way you live are on Forum, the North Idaho College Public Forum, with your host and moderator, political scientist Tony Stewart.
Welcome to the fourth and final program in our series entitled Facing the Threat. Our subtopic today of that series is Extremist Groups, the Constitution, and Law. I want to thank the Northwest Coalition Against Malicious Harassment for providing our guests over the last 4 weeks due to a conference they were holding at Gonzaga University in Spokane, Washington. Our guest today is Brian Levin. He is an attorney. He's also a professor teaching civil liberties and criminal justice at the Richard Stockton College in New Jersey. Our guest is also a former staff member of the Southern Poverty Law Center, one of the best-known research and human rights, civil rights groups in America. Brian, thank you for coming so far west and being at this conference as well as on our program. We appreciate it very much, and we're particularly delighted that we have someone who has an expertise that they will share with us concerning this particular issue. Welcome to the program.
Well, thank you for having me, Tony.
I want to talk to you first about a number of extremist movements that we've already identified on previous shows this month, and so we don't need to go back in and talk about their ideology and all that. Our viewers have obtained that information. But what I'd really like to do is to concentrate on your expertise in law and the Constitution. I would have a two-part question to start out with, and I'll just take one part at a time. First of all is the First Amendment to the Constitution and how those interpretations of those very, very basic principles in that amendment and how that relates to extremist groups we see in some countries like Germany. When extremists do certain activities, the law is very strict on what they can and can't do. And in this country, the interpretation of that amendment gives a lot more leeway. In this very general, broad way, would you share with our viewers and inform them about how you perceive that issue?
Sure, and I think you actually gave a very interesting introduction. And let me maybe explain it by virtue of an example. There's a fellow named Gerhard Lauck. They call him the Farm Belt Führer. He actually has a Hitlerian mustache, and he talks with a German accent, even though he's, not from Germany. And he is one of, or I should say was one of, the largest worldwide purveyors of hate literature. And in Germany, the Nazi salute, for instance, is outlawed, and this kind of hateful Nazi literature is outlawed as well, but it's not outlawed in the United States. So he was sending this out through the mails, and he'd occasionally make trips to Europe. And recently he was imprisoned because he made the mistake of going over to Europe, where he was arrested by authorities in Northern Europe and then extradited to Germany. And he's now serving time for disseminating that information. Here in the United States, the First Amendment of our Constitution, which prohibits the government from abridging our freedom of speech, our rights with regard to speech and expression, and also our right to associate, effectively limits the government from denying us the opportunity to have our say, even if it's offensive, even if it's hateful, and even if we attack racial, ethnic, or religious minorities in doing so.
In a verbal way.
That's correct. Let me just say, so people don't think I'm advocating stuff that I shouldn't. Yes, what I'm talking about is offensive kind of speech. And under the First Amendment, which was ratified in 1791 as part of the Bill of Rights, the courts have construed that amendment as giving very wide protection to a vast array of speech. Not all speech is protected, though. Certain kinds of things like threats, for instance, or incitement to imminent lawlessness is unprotected, as well as obscenity and some commercial speech. For instance, I couldn't sell you my car and say, never been in an accident, it's got 2,000 miles, knowing that it might have been an accident and has 120,000 miles. So free speech rights are not unlimited, but they are regarded as fundamental. And the First Amendment protects citizens from governmental interference with their free speech rights. And that applies not only to the federal government, but through the 14th Amendment, it's been applied to the states and local governments as well. So the local sheriff or the governor can no more interfere with your rights to free speech than the president.
And so in this democracy, with the very broad principles of democracy, individuals can even speak out who really oppose democracy, as long as they don't take certain actions. Is that correct?
Absolutely, absolutely. In fact, abstract advocacy of violence is constitutionally protected. However, some things that aren't constitutionally protected, let me make sure that I'm clear on this, because I don't want people calling me up and saying, hey, I'm in jail now and you said the wrong thing on public television. Conspiracies, for instance, and a conspiracy is a criminal plan among two or more people, plan to commit a crime, and some affirmative step in the furtherance of that crime. That can be punished criminally. In addition, incitement to imminent lawlessness, that can be criminally punished. But that's different from saying that one supports violence in the abstract to achieve some social goal. And that's where, as you can see, the line can get a little bit fuzzy. So it has to be, with the incitement, for instance, there has to be some kind of likelihood of the lawlessness being carried out. There has to be the intent of the person saying those words to actually have that occur. And that's why, for instance, certain types of fiction, or give you an example, there's a Supreme Court case involving a man named Watts, and he said, if I'm drafted into the Vietnam War, the first person I'm going to get in my rifle sights is LBJ. And of course, the government can punish threats, particularly threats against the president. But the Supreme Court in that case said that that was really just a crude political statement as opposed to a genuine bona fide threat. So abstract talk and abstract hatred or abstract calls to violence is protected, but specific incitement to violence and conspiracies are not.
So a distinction between speech and illegal action. And also that has to do with some other things we'll talk about in a minute concerning hate laws. Let's move for a minute to the 14th Amendment, because some of the extremist groups that you have studied, and I want to also point out that you were the founder of the Center on Hate and Extremism that's at your college when I introduced the program and indicated that college in New Jersey. A number of extremists who are particularly involved with white supremacy and want white men to govern, and even it's biased against women, and also obviously people of racial and ethnic minorities, don't like the 14th Amendment, because in the 14th Amendment, when it guarantees the protection of individuals, no person shall be denied the protection of the laws, that's been used for very effective civil rights implementation. Would you take us through, first of all, what the extremist argument is about why they don't accept the 14th Amendment while they will accept the Bill of Rights? That we'll start with that.
Well, I don't really think they have a rational basis for saying that the 14th Amendment wasn't ratified. It clearly was. I've heard a broad spectrum of cockamamie ideas as to why the 14th Amendment is not good law. It in fact is, but they would say it wasn't ratified properly, or it contradicts certain organic rights that were in the Constitution that only are extended to white males. I mean, there are so many cockamamie ideas on the illegitimacy, in quotes, of the 14th Amendment, that it's really hard to address them, because it's we were sitting down and I'm looking at you and saying, well, Tony Stewart's green. That's it. Tony Stewart's green. And there's really that level of legitimacy and credibility to those statements. With regard to what the 14th Amendment is, in the post-Civil War era, there were certain amendments that were passed. The 13th Amendment was one that abolished slavery. The 14th Amendment granted citizenship rights regardless of race. So it extended citizenship rights to newly freed slaves. And of course, the 15th Amendment extended the right to vote, suffrage, but not to females. That had to wait until this century. So it was one of three really crucial post-Civil War amendments. But the interesting thing about the 14th Amendment, there are a couple of things. First of all, as I said, it extends citizenship to all persons born or naturalized in the United States, and it effectively granted citizenship to newly freed black slaves. Additionally, the 14th Amendment called for equal protection, and one of the things that is hopefully prevented when 14th Amendment cases came up to the Supreme Court is treating similarly situated people differently, at least as far as the government is concerned. That wasn't allowed. And another thing that the 14th Amendment did, which some people in the Patriot movement don't like is that it also limited the conduct of the states. Now, as I'm sure you heard in some of your previous shows, the scepter of states' rights has been used as a code word oftentimes to limit the rights of minority citizens. What the 14th Amendment did is it applied certain fundamental constitutional rights that were in the Bill of Rights, like freedom of speech and freedom of religion, to not only citizens of the United States, but to citizens of the individual states. What does that mean in practice? It means that the state government, state officials, state police, state governors can no more interfere with your right to freedom of religion or freedom of speech or unreasonable search and seizure for that matter in any different way than the federal government. It restricts both the hands of the federal government from doing things in the initial Bill of Rights, but it applies those fundamental rights in the Bill of Rights to limit the activity of state officials as well. And one example, of course, is that the state officials can't unconstitutionally limit your free speech rights. And until the Supreme Court started having these cases come to them saying, does the First Amendment tie the hands of the state officials with regard to limiting someone's freedom of speech in the same way that the federal government officials are? We had a jurisprudence that said only federal officials are limited and not state officials. So what we had was various rights that were considered fundamental were protected from encroachment, not only by the federal actors, but by state actors as well.
And those radical groups that don't like the 14th Amendment and really they don't like certain basic things of the First Amendment, if they were in charge and control, they would rewrite or reinterpret the Constitution to where, one, that white males would run and run the government, make decisions, and secondly, those who disagreed with them would not have the kind of protections of free speech they have today. Is that not one of the basic differences between what we really have in this country and what they are trying to advocate?
I think that's right, and also it guarantees privileges and immunity, and it also speaks of equal protection under the law. I mean, at its core, and again, the Patriot movement is a broad spectrum, so I think we're hooked onto the same wavelength of the kind of people we're talking about. But they don't believe in equal protection for non-white citizens. Certainly some of these people, not everyone in the Patriot movement. It's a very broad spectrum. But for those that do adhere to this ideology that you speak of, I think you're exactly right. These are people who want a country where white male Christians, and only their definition of white male Christians, would be able to participate in democracy or be able to exercise rights. And that's clearly something that is just completely, categorically intolerable with our democratic society and diverse society as well.
Thank you. Let's get into some statutes that are based on the Constitution. And
Sure.
In a dialogue that I had with you on the phone, I was intrigued with some of the things you said. Let's start with the federal level and then compare it with the state. It's very hard to give a clear title to these laws. They're laws that address hate crimes and malicious harassment of individuals. Can you just, with the short time we have on this program, can you kind of give us a overall view of what we have at the federal level and the state level?
Sure. At the federal level with regard to hate crime, and let me just tell you what a hate crime is, because it's a moniker
Yes.
now that has both legal meaning but also the social meaning, so let me try and stick to the legal meaning. A hate crime law is a law that punishes the discriminatory selection of a victim in a crime. So if I say, I'm going to commit a crime, and I say, I'm going to commit a crime against you because you're white or because of your religion, then it rises to the level of a hate crime. And there are two types of statutes that deal with hate crime. One is what I'd call the standalone statute. A malicious harassment statute could be an example of that, where it's a separate chargeable offense to interfere with the rights of an individual because of his race, religion, or her race or religion.
So they could be charged under the crime itself, like a battery or whatever, and then this would be a second enhanced charge.
Well, actually, it wouldn't be an enhanced charge. It would be a separate charge.
Okay.
And indeed, for instance, in California, for example, their hate crime statute, actually they have an enhancement as well, but they have a standalone. Their main statute says it's a crime to interfere through force or threat with the civil rights of another based on race, religion, etc. That's the standalone. There's another kind of statute which went up to the Supreme Court and which now has some it's slightly more favored because the Supreme Court ruled on this specifically. That's an enhancement. And under the criminal law, we have enhancements all the time. We have the enhancements, for instance, if you mug a process server or a fireman or a police officer, firefighter, I should say, or a police officer while they're working, that's a different kind of offense than if you do it to somebody else. If you rob a bank as opposed to a liquor store, if you deal drugs within a certain distance of a school, if you rob somebody with a gun as opposed to a knife. The criminal law is evolving, and it constantly takes into account the situational nexus in which a crime occurs. With the enhancement, what the statute does is you have to be charged with something else, such as a battery, a homicide, arson, something like that. And then, if it's found that you committed that crime, then there's an enhancement if it can be proved beyond a reasonable doubt that you selected that victim or that property because of status, such as race, religion, etc. So they're slightly different, but they operate the same in the sense that an offender can get extra time for interfering with the civil rights of a victim, if you call it under that law, or if you intentionally select a victim because of their status. When I say status, that's race, religion, sexual orientation, etc., disability.
In regardless of which prosecution takes place, both of those laws and options would take into consideration the fact that this was a victim because of hate.
Right, but the thing that's interesting here with these laws, and the reason why they're constitutional, is because we can punish discrimination. We can punish discrimination in the civil area, in employment, and housing. We can also punish it under the criminal law. We can punish the act of discrimination. What we can't punish is the prejudiced beliefs that might lead to the discrimination. And that's why there was a law that was thrown out a few years ago by the Supreme Court, because instead of targeting the discrimination or the terrorism involved with these hate crimes, it said if you express a belief or use a certain symbol to express a belief in committing a crime, then you'll have a jail time. And the Supreme Court said you can't punish the content of the ideas expressed in the commission of a crime, but you can punish the crime, and you can punish the discriminatory selection of the crime victim.
We're back to the distinction between offensive language that is protected versus the illegal action.
Exactly, and the Supreme Court actually spoke of this. There were several justifications that the Supreme Court gave for signing off on the constitutionality of these hate crime statutes. I came up with a theory on the constitutionality of these statutes in a couple of ways. One, we can punish discrimination, and the Supreme Court accepted that line. The other thing is hate crimes are more severe. They're more likely to involve assault. They're more likely to involve injury. They're more likely to involve serial attacks, which escalate in severity over time. They're harder to solve. So there are a whole bunch of objective criminological reasons, separate and distinct from the fact that I happen to loathe bigotry and anti-Semitism, which we can't punish. What we can punish is the discrimination. But, for instance, if there was an offender out there that wanted to interfere with the civil rights of someone, not because they were bigoted, but because they had some cockamamie theory of something. Maybe they thought, if I go after white people, I'm a white person, I select white people for a crime because I want to strengthen them, and each time I attack them, it'll cause whites to be more cohesive or something. And I actually like white people, and I select them intentionally to be the victim of a crime. Technically, that would be covered as well. So what we're punishing is the discrimination and the fact that these crimes are more severe. And luckily, the Supreme Court adhered to that. The other thing that they said with regard to the free speech was, look, bigots and Nazis have a broad spectrum of activities that they can do that are protected under the First Amendment. They can march, they can hold rallies, they can write books. What they can't do is try and cloak themselves in violence and use that as a shield to prevent themselves from prosecution merely because they have bigoted beliefs that rise to the level of violence. And in the same way, for instance, we have laws against assassinating the president, and many people will want to assassinate the president because of political views, but that will not shield them from prosecution.
Right. One other thing on that, and I want to get into some questions about some research you're doing concerning hate crimes in the military, but one of the rationales behind states passing, and Idaho, by the way, has a long list of laws to fight against hate crimes, and the legislature has been very effective in passage of those laws. But one of the rationales that I'd like for you to respond to is that those laws have become popular in their passage around the country because if a person belongs to a particular group that has faced lots of discrimination, for example, the Jewish community. And when individuals are, or African American community, walking the streets, and because one is identified as a member of that community, they are more subject to violence. Is that one of the rationales also behind the laws, to send a loud message that hate crimes receive some very, very definite attention in the criminal law?
Absolutely. A colleague of mine, actually two colleagues of mine, Jack Levin, no relation, and Jack McDevitt out of Northeastern, did a study, and they found 60% of hate offenders did it for one motivation, for excitement. So it's a very deterrable type of offense. And if people know that, A, this is not the view of the community, sometimes silence is taken as tacit approval for these acts, and the other thing is that there's meaningful punishment associated with these offenses, I think there's a significant effect on it. But one thing that's important from a constitutional standpoint, bringing us back to the 14th Amendment, these kind of laws have to punish offenders whether they attack a white person or a black person, a Jew or a Gentile or a Muslim. We can't have a set of statutes that would say if we intentionally select a minority member but not someone else, it would be a crime. That would violate equal protection of the laws.
Yes. In our discussion, you indicated to me earlier that you were concerned that in the military, we've had some incidents recently about individuals being attacked on racial grounds and other factors, and that there's some problems with lack of legislation dealing with the military. Would you explain that to our viewers?
Absolutely. Unlike the states, which about 38 states now have broadly applicable hate crime laws, of the kind that I spoke of, the standalone or the enhancement. The federal government has a sentencing enhancement law. For instance, if you commit a federal offense and it can be shown that you selected the victim because of their status, that would hike the penalty. I think if there's one area where there's a big void, it's in the military. The Uniform Code of Military Justice regulates the laws for military personnel, and we have 1 to 2 million people under military authority. And we've seen some examples of hate crimes in Sasebo, Japan a few years ago, where there was a homophobic homicide, or in Fort Bragg, where we had enlisted people murdering civilians because they were black, would cause me to believe that it's high time that the military address this through legislation. So I think the Uniform Code of Military Justice must be changed so that, like 38 states and the rest of the federal government, that it addresses the problem of hate violence. Indeed, historically, the military has addressed racial issues sometimes better than the rest of the country, for instance, with the desegregation of military bases back in 1948. But I think this is an example where the military, unfortunately, lags behind. They need to enact legislation that will criminalize this kind of conduct, and they also need to do a better job of collecting data on the number of hate crime incidents that take place by and between enlisted people and on military bases throughout not only the United States, but throughout the world as well.
There's a national vice crime reporting law that was passed in 1990 in which the federal government and the states in law enforcement do collect data, which is helpful for a number of reasons. But the military doesn't have any particular policy to collect that data. Is that correct?
I believe they're starting to collect data, but it's in a very limited form. I haven't seen any widely disseminated public reports. I know they're taking steps to collect data, but they're not governed by the Hate Crime Statistics Act. So
right.
What we must do is have the military respond to these crimes in the same way that we have in the rest of society. And data collection is important because it's a gateway initiative. I've done some work with regard to the promulgation of the Hate Crime Statistics Act, and one of the things that we see with the passage of these things at both the state and the federal level is that you'll have policies and procedures dealing with hate crimes once you have data collection put in place. You'll have training of the officers, and you'll have a greater awareness to respond to this. In addition, it's very important to know how to allocate resources to get that kind of information. So there are manifold reasons on why we should have data collection really put into the military in some kind of systematic way, and also to have the criminal statutes that govern the military also address this kind of scourge as well.
That requires action by the Congress of the United States, and I know you've been working on that, and you probably have a barometer of that process. What do you think the chances are that Congress will act in the near future in this area where you feel there's a void?
I think it depends on this next election. I think with the current Congress that it is not a very likely outcome. I think perhaps if there's a change in Congress, the outcome would be more significant. The chances would be more significant of that happening.
Let's talk a little bit more about statutes in relation to the whole business of trying to combat this problem of hate. If you, and I may ask a question that you don't have the data on, and I apologize if I do, but as you survey across the country, what are some of the characteristics that you find in legislation, or what states have some provisions you think are the most effective?
With regard to hate crime?
Yes, and we're talking about malicious harassment laws that deal with criminal and civil sections and so forth. There's states with anti-paramilitary training laws for groups that go out for the purpose of training militarily for violent action. What, if you were advisor to a state, what would you suggest that they go do in relation to provisions?
Well, I'd look to a couple of things. With regard to hate crime laws, I think California has an excellent array, not just one law, but an excellent array of laws that cover hate crimes. You have to look at a couple of things. What groups are covered? You want the broadest number of groups possible. You want to cover disability. You want to cover gender. You want to cover perhaps even immigrant status as well. So you want to have broad coverage, broad scope that way.
Because you're suggesting there are a number of groups that face this kind of problem.
Sexual orientation is perhaps one example where we really, in many states, for instance, New York does not cover sexual orientation, and many other states don't cover it as well. Sexual orientation must be covered for it to be an effective statute.
Because there's a lot of victims because of that, because of sexual orientation.
Homophobic homicides have outpaced racially motivated homicides, I believe, for the last couple of years. So it's really important that we address the scope of what groups are covered. The other thing that we need is we need to have teeth in the statute. There has to be a severe enough penalty associated with it. And the last thing is we have to have it applied to a broad range of circumstances. In some states, it's only limited to assault or vandalism or arson. I think that that's not a good idea. I think we want to have something, for instance, like Wisconsin, which says just the victim of a crime. So if the property or the victim is selected because of these broad status categories, the punishment then will take place. So in three ways: the severity of the crime, the severity of the penalty, the situations in which that penalty can be imposed, and the number of groups it protects. Those are the three things that legislatures have to look at. With regard to paramilitary statutes, we have to have laws that cover both militia organizing and paramilitary training.
You did a really good job of covering that whole area in such a very short time. And Brian Levin, thank you for being on the program, and we found it extremely informative. Ladies and gentlemen, with this program, we end a 4-week series entitled Facing the Threat. We want to thank the Northwest Coalition Against Malicious Harassment for providing these guests at their conference at Gonzaga University in Spokane, Washington. Please be with us again next week when we'll move to yet another issue. Until then, please have a good week. I am Tony Stewart.
The North Idaho College Public Forum was videotaped live from the studios of Telemedia Services on the campus of North Idaho College for viewing at this more appropriate time. We invite you to join us again next week for another all-new edition of the North Idaho College Public Forum on this public television station.